actually stack those possibly. So you potentially could be looking at up to 25 years in prison.
So let's begin.
Mr. Musgrove, you want to come up to the podium, please? This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger-Margosian might, oh, there he is. So, Mr. Dagger-Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger-Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course,
none of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over.
Facing 25 years in prison, and this guy rejects his own lawyer. You won't believe what argument he tries in court. This gets shut down fast. Hit subscribe right now because this case is about to get wild.
So
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger-Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid. And it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off it. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have all
in
these.
order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case.
The victim would be the company.
You are charged.
I can't face
Ashley, just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years. You're charged in count two with using using a computer to commit a crime to facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can. Yes,
They
they
can?
can. Yes, they
Okay.
can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes,
but
they
they're
can.
going-
Yes,
They're
you
going
can
by
be charged.
everything, all the
can't-
laws and statutes that you guys go by
Are
are for
legal.
corporations. They're for
Still a crime. Still a crime.
But I'm not
Still a
a fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're
Okay.
standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid. It's
Okay.
not legal.
right.
So do you want to represent yourself or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm going to set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr.
So
Most
here's the
people
situation.
facing a potential 25 years in prison would do one thing above everything else. They would listen to their lawyer. Brian Joseph Musgrove did the exact opposite. Charged with embezzlement of nearly $70,000 from his employer, Hardwoods of Michigan Industries, and facing 2 serious felony counts, he walked into a Michigan courtroom and fired his public defender. Not because the attorney was bad. The judge herself described the public defender's office as filled with exceptional, highly experienced attorneys. Musgrove fired him because he had a different plan entirely. His plan was sovereign citizen theory. Like the woman in the previous video, Musgrove believed he could use a set of legal-sounding arguments to escape the court's jurisdiction entirely. He tried to argue that the court was a private for-profit corporation. He claimed that because he was a living person and not a corporation, the laws and statutes of the state of Michigan did not apply to him. He suggested that because the victim in his case was a business rather than an individual, he had no one to face as his accuser. And he raised the idea that when he turned 18, he was supposed to reclaim some kind of minor status, a theory he attributed to the Supreme Court. The judge shut down every single argument with calm, direct precision. On the claim that the court was a profit-generating system, she pointed out that she is paid a salary by the state of Michigan regardless of the outcome of any case. On the idea that a corporation cannot be a victim, she was clear, it is still a crime. On the notion that a business cannot face him in court, she explained that a representative of the company absolutely can testify on the stand. And on the Supreme Court theory about claiming minor status at age 18, her response was simply not valid. Not valid under the law of the state of Michigan. Not valid under the Constitution of the United States. What makes this case particularly striking is the scale of what Musgrove was walking away from. His public defender, Michael Dagger Marosian, was still present in the courtroom, willing to stand by as counsel even if Musgrove chose to represent himself. A trained, experienced attorney, ready to help, and Musgrove chose internet theories over legal expertise. Count 1 alone, embezzlement of over $50,000, carries up to 15 years in prison. Count 2, using a computer to facilitate that crime, carries an additional 10 years. And the judge made clear that those sentences could potentially be stacked, bringing the total exposure to 25 years. In the end, Musgrove asked for more time to think. The judge set a new pretrial date and adjourned, and that, in itself, tells you everything. After all the arguments, all the theories, all the confident legal-sounding language, when it came down to it, He needed more time to think, because deep down, somewhere beneath the sovereign citizen ideology, there was a man who realized he was standing in front of a judge with the power to send him away for a very long time, and his theories were not going to save him. The lesson here is not complicated. The legal system is not a puzzle you can solve with the right combination of words pulled from an online forum. Courts have seen these arguments hundreds of times. Judges are not confused by them. And when you are looking at 25 years of your life, the smartest thing you can do is trust the person who spent years studying the law to help you, not spend that time trying to outsmart a system that has already seen every trick in the book.